Masterclass focused on the new Ontario auto reform changes. I'm Amanda Turner, and I'm joined by Michelle Atwood and Heather Bryan today. Before we start, I wanted to quickly run through a few items. The Masterclass has been submitted for REBO accreditation, and we will pass on any certificates should it be approved. Also, today's session is being recorded. We will post the full recording on our YouTube channel and send it directly to everyone who registered but was unable to attend the live session. If you experience any technical issues during the webinar, please try refreshing your browser first, and if the issue continues, let us know in our chat and our team will assist you. We will make time for Q&A toward the end of the session. You can submit your questions at any point using the Q&A feature at the top of your screen, and I will be monitoring throughout. If we run out of time and do not get to your questions, we will follow up afterwards with responses and additional resources. Take it away, Michelle.
All right. Thanks, everyone, for taking time to join us here today over your lunch hour, no less. Very excited to be part of this masterclass session and to have the chance to connect with all of you here virtually. We've got a nice mix of people joining us today in terms of adjusters and brokers and other stakeholders in the industry, and we're hoping that you'll find this to be good and informative as we're coming into the July 1st auto reform. I can imagine probably many of you have heard quite a lot of buzz already about the July 1st changes, why they're coming into effect, and some of the sort of facts and details and intricacies about it. But what our goal is to do here today is to bring you through it even further and deeper and to answer any questions that you might have. As mentioned, my name is Michelle Atwood. I'm a claims adjuster here with Crawford, and proud and a little humbled to admit that I've been in the industry for 25 years now. And I can tell you over the years, we've seen all sorts of changes with accident benefits and constantly changing regimes. So as we jump into it, let me just move this slide forward. Oh, and I'm sorry, I'd be remiss to not mention, unfortunately, Michael McNeil, our senior general adjuster and one of our practice leads, is not able to join us today. He'd originally intended to be part of the presentation and was a huge part of building it. Unfortunately, has suffered a family emergency and can't be with us, but his contact information will be at the end of our presentation, and he would be more than happy to hear from any of you with any questions or follow-up discussions. Our agenda for the next hour is to talk about accident benefits. Very briefly, we'll talk about where it all began. We'll go through a bit of a history and chronology of how we got to this July 1st change. And then we'll get into talking about what the change is. So what is going to become mandatory coverages, what we'll see in terms of optional coverages, why the changes have transpired. We'll then move into talking about the transition periods. So what happens after the July the 1st in terms of accidents occurring on or after July 1st, but also in terms of existing policy, renewing policies, and how the changes will come into effect. We'll move into talking about what benefits are becoming optional and how the priority of payment rules are going to impact people who have been involved in accidents in Ontario after July 1st. And from there, we'll talk about anticipated impacts, somewhat hypothetical, but certainly a good conversation, and we hope will be informative overall. So where it began. Before 1990, Ontario operated on a largely fault-based tort system. So if an individual is injured in a car accident, they're not liable for the collision, they would look to sue the liable party for compensation. And those lawsuits would cover everything from economic losses, including income losses, medical, rehab, attendant care, housekeeping, and then, of course, the non-economic losses such as pain and suffering awards. There was, in some cases, optional benefits that could supplement this tort-based system. Schedule E accident benefits, as you can see there, could be available to people hurt in collisions with up to about $2,000 of medical coverage and about $35 per week for disability. Obviously, that's not very much. The problem with this system before 1990 is that each and every claim where there is another party at fault, we're seeing lawsuit after lawsuit after lawsuit brought forward with insurance companies having to respond, even with the more minor collisions. If you've suffered an an accident, you've suffered an injury, you're not able to work, you've incurred some treatment costs, your only recourse to be compensated is to sue that other driver. Their insurer responds. So the problem there, of course, premiums are skyrocketing, courts are in crisis, and claimants are largely without access to care, waiting months, if not years, for lawsuits to develop and eventually settle. The solution with this problem, as the system's in crisis, is to introduce no-fault accident benefits. With the introduction of no-fault accident benefits, we first saw in June 1990 the Ontario Motorist Protection Plan brought forward. And you can see by this chart, we've had a lot of changes since, bringing us forward until July of 2026. We won't go through this in depth. It would take us much more than an hour to do so. But basically in 1990, no-fault accident benefits were introduced. And with that, there were very strict thresholds imposed to limit the tort opportunities. So the goal was to move from this purely fault-based system into a no-fault system where people access accident benefits. You can see they can have up to $500,000 of non-catastrophic med rehab coverages. They can get up to $450 per week for income replacement. And the goal is to reduce and in some cases eliminate lawsuits from the system. Moving forward into 1994, we see Bill 164 introduced. This system is unprecedented in its generosity with uncapped lifetime benefits available for people for medical rehabilitation, attendant care. We've got income replacement benefit up to $1,000 per week. Coming into 1996, the system is in crisis once again. Insurance is paying out so much money for these claims, we have to basically slam on the brakes. And that's where Bill 59 brought in the $100,000 limits for non-catastrophic med rehab, $72,000 for attendant care. With the introduction of Bill 164, some years later, we see the idea of catastrophic impairment brought in to further control costs. Then we move forward into OREG 3410, September 2010. And this is a system that most of us know because this is the system we've been working with for quite a long time. This was a massive overhaul of the SABs. In 2010, we saw $50,000 limits for med rehab, $36,000 for attendant care. Fast forward to 26, that's reduced to a combined limit of $65,000 as a maximum coverage limit. For years now, we've had income replacement benefit at a limit of $400 per week. We've had non-earner benefit at $185 per week. We've had this catastrophic definition gradually changing and morphing to make it more and more restrictive. And over the years, this very, very generous accident benefit system has slowly been reducing in order to try to control costs and premiums, but also to still serve the consumers well. So coming into July 2026, July 1st, 2026, as put forward by FSRA, the Financial Services Regulatory Authority of Ontario, we are only going to have medical rehabilitation and attendant care benefits mandatory on these policies. All other benefits will be optional. And we've often heard the phrase, it's moving to an a la carte system. So FSRA advertises that this change, July 1st, 2026, will allow consumers more flexibility to choose coverages that fit their needs and budgets. So let's talk through that. On and after July 1st, 2026, still mandatory are medical and rehabilitation benefits. As we've seen for many years now, minor injuries can be compensated to a coverage limit of up to $3,500. So this minor injury med rehab, it can pay for your physiotherapy, it can pay for counseling, it can pay for chiropractic, massage therapy, prescriptions, up to $3,500. A minor injury, as I'm sure probably most of you are aware or can speculate, is defined as one or more of a sprain, strain, whiplash-associated disorder, contusion, abrasion, laceration, or subluxation that includes any clinically associated sequelae. If we move up to the next category of coverage, med rehab benefits, no change from June 30th to July 1st. We're still at a $65,000 limit combined with attendant care for medical and rehab benefits. And that coverage is available for up to 5 years. So again, we're talking about physiotherapy, occupational therapy, massage, prescriptions, assistive devices, and whatnot. A non-minor or a non-cat injury, we often think about individuals who have suffered concussions or fractures, complete tears, that sort of thing, but not so severe that they would be declared as catastrophically impaired. A catastrophic injury coverage is up to $1 million. And again, this limit is med rehab combined with attendant care, and catastrophic coverage can be available for a person's lifetime to the extent that services are reasonable and necessary. So all of these first three bullet points are unchanged from before July 1st to after July 1st. We're still at $3,500, $65,000, and $1 million for the minor, non-minor, and catastrophic coverages. The one change that we're seeing, though, post July 1st has to do with priority of payment. Historically, where an individual has extended healthcare coverages through a workplace policy, for example, historically, that extended healthcare coverage is considered primary for payments. So if I have an injury and I go to a physiotherapy clinic, I have 80% coverage for my physiotherapy needs. I first have to submit to Green Shield, for example, and then the auto policy pays the balance. This is no longer the case. For accidents on and after July 1st, the auto policy will now be the primary payer for all treatment-related needs, with the exception of medications. So going forward after July 1st, we'll still expect prescriptions to go first to that extended health coverage, and any balance that is outstanding to come to the auto claim. Still mandatory is attendant care. Again, with this combined limit with medical rehabs. No change in the fact that minor injuries still have no coverage for attendant care needs. And for those who perhaps don't have as much depth or knowledge or experience with with accident benefits, attendant care benefits will pay for the services of a personal support worker, or in some cases, a relative who perhaps has to take time off work to attend to your personal care needs, where your injury is of significance and you need that sort of support. So no coverage for attendant care if you have a minor injury. But for those who have the non-minor or non-catastrophic injury, you can have up to $65,000 combined with med rehab, with the amount not to exceed $3,000 per month, and the benefits available up to 5 years. For catastrophic, still at $1 million combined with med rehab, not to exceed $6,000 per month, available for a lifetime. So again, no changes there. In past, we have had optional benefit coverages available that we can purchase to enhance those standard coverages. Some of you may know that the standard $65,000 of non-catastrophic coverage can be increased to $130,000, or it can be increased to $1 million. Likewise, the standard catastrophic coverage can be increased from $1 million to $2 million. These optional coverages are still available on and after July 1st, so no changes to those optional benefits being available for purchase on policies. The big changes are with everything else. So as of July 1st, 2026, and with policy renewals, we're going to see that income replacement benefits are no longer mandatory on the standard auto policy. This is a really significant change. I've read that somewhere between 20 and 25% of all accident benefit claims include a payout of income replacement benefit. And just to recap, that income replacement benefit standard coverage is at $400 per week. So if I'm injured in an accident and I can't work as a result of that injury, prior to July 1st, I can access up to $400 per week of income replacement benefit. But after July 1st, if I haven't purchased the optional benefit and if I no longer have that coverage on my policy, that benefit's no longer available to me. The tricky part with the income replacement benefit, and we'll talk about this in a bit more detail, but the challenging thing is when consumers have to consider whether or not they want to purchase the income replacement benefit, for the most part, consumers have no idea how an income replacement benefit is calculated or how it gets paid. Historically, the income replacement benefit at $400 per week as a standard can be increased to $600, $800, or $1,000 per week. On and after July 1st, income replacement benefit will be available only if it's purchased as an optional benefit, and the coverage amount will be limited at a fixed rate at the point of purchase. So if an individual chooses to buy $400 or $1,000 of coverage, that's the maximum entitlement that they would be able to receive on a claim beyond July 1st. The difficult part is, as I said, consumers don't necessarily know how the benefit is calculated. Just because I have $400 per week of income replacement benefit available as a maximum entitlement doesn't mean that that's how much I'm going to receive. The benefit, it's calculated based on your gross pre-accident income. So on average, if I'm earning $1,000 per week prior to a collision and I get into an accident, my benefit is calculated based on 70% of my $1,000 earnings. I'll receive up to $700 of income replacement, but my coverage limit is $400. So I'm capped and I only receive that $400. If I have disability benefits, if I receive post-accident earnings, that will affect the calculation of how much I'm going to receive. Again, the consumer doesn't know how all of this will play out, and they're going to have to rely on their brokers, their insurers, and their adjusters to help them understand. And they're going to have to hope that they've purchased adequate amounts to cover them for their needs if they are indeed involved in a collision. The non-earner benefit can still be available to people. Again, it's an optional benefit now. Non-earner benefits are relevant to people who do not otherwise qualify for an income replacement benefit. It can be paid if an individual suffers a complete inability to engage in normal life. It can be paid to people who were not working prior to an accident. It can be paid to people who were full-time students prior to an accident or had been a recent graduate. Non-earner benefits are paid at $185 per week after a 4-week waiting period and not beyond 2 years. So typically, and not beyond the age of 18. So typically this benefit is relevant for young people who are in post-secondary studies, for example. It's a way that they can still receive compensation despite the fact that they weren't earners prior to the collision. I don't know that we're going to see many folks purchasing up non-earner benefit. To be frank, I suspect probably not, because it's such a minute grouping that would ever typically access this benefit, but I suppose time will tell. The next optional benefit is the caregiver benefit. We often hear the term specified benefits. So in the accident benefit realm, specified benefits are income replacement benefit, non-earner benefit, caregiver benefits. A person who's injured in an accident can only ever receive one of these three benefits. If they're eligible for more than one of them, they have to elect which one they're going to receive. The caregiver benefit is payable if a person has dependents who resided with them at the time of the collision. They were the primary caregiver to that individual, and as a result of injury, they can no longer provide care. So they have to hire someone else. Perhaps they hire a live-in nanny or they hire a babysitter. They're incurring a cost. Maybe their spouse has to take time off of work. They're not being paid as a result. In those types of situations, an individual can claim a caregiver benefit, again, so long as they're not receiving an income replacement benefit or a non-earner benefit. So it's just one of those three. Here too, the caregiver benefit is only going to be paid if the optional benefit is purchased. How much is an individual going to purchase? A consumer making that decision at the point of a policy renewal or at the point of purchasing a new policy, they're going to need to be informed by their insurers and their brokers as to how the benefit works, how much might be available, what might be recommended. You can imagine me, if I'm a mother of a 15-year-old teen who's mostly independent and out and about and doing their thing, that's not nearly as stressful as if I have triplets who are 2 and a 5-year-old. So in these types of situations, we really need to consider the context of what a person's family life is like, whether or not the caregiver benefit makes sense for them to purchase, and how much do they want to consider purchasing in terms of that limit to be fixed by optional benefit. One change that we're going to be seeing with this caregiver benefit, in past, the caregiver benefit was available to people if they were declared to have suffered a catastrophic impairment. That was part of standard routine coverages. With the optional benefit, that's no longer the case. So if I have suffered a fracture, I'm in that non-catastrophic category, but I have the caregiver benefit purchased, I am able to access the caregiver benefit regardless of the level of impairment, so long as I have it purchased on my policy. Also, optional coverages that used to be standard are lost educational expenses and visitors' expenses. And here again, this is a sort of an ongoing theme. Consumers are going to really have to consider what they need, what their family circumstances are, what they might expect to come at them if they're injured in an accident in terms of costs. So lost educational expenses in past could reimburse an individual if they were unable to continue in their studies as a result of impairment due to collision. So we think about post-secondary students, they're halfway through their semester, they've paid their tuition, they've paid their residence, they've paid their meal plan, they've bought their books, and they're derailed. For people like that in past, they could use this lost educational expense benefit to pay up to $15,000 to reimburse them if they're not otherwise reimbursed by their university for those costs. So going forward, consumers have to consider, what is the family circumstance? Do I have kids who are entering university? Is it possible that my kids would be claiming under my policy? Is it possible that I need this benefit available as a safeguard? Very individual decisions, of course. And likewise with expensive visitors, where we see individuals hospitalized as a result of a collision, Sunnybrook and St. Mike's come to mind, the cost of parking can be $30, $40 per day. In past, expenses of visitors were always covered. It was mandatory on the policy, and it would pay for reasonable costs of direct family relatives that were visiting during a person's, typically during their acute period, but reasonably at any point, as long as it was considered reasonable. Sometimes we've seen claims where we have international students here in Ontario, they get into an accident and their relatives are flying from overseas. They've got hotel costs, they've got airfare, they've got the parking, rental cars and whatnot. In past always covered, not now. So again, here too, family circumstances, individuals thinking about purchasing auto insurance have to consider what their risk tolerance is and also what they expect might happen if ever they were to be hurt in an accident. The nice thing about these optional coverages is they tend not to be overly expensive to purchase. And so again, consumers making these decisions, they'll need to be informed about what the coverages are, how much they cost, and then they can make their risk-based decisions around what makes sense. Housekeeping and home maintenance is now an optional benefit. In past, housekeeping could be made available to people if they were catastrophically impaired, up to $100 per week to pay for the services of a housekeeper to come in. If expense was incurred, it would be reimbursed. Now with the optional coverage, housekeeping and home maintenance coverage limit can be fixed at the optional benefit amount chosen, and it is no longer restricted just to the catastrophically impaired claimants. It's available regardless of impairment level. Although with that, if an individual is not catastrophically impaired, they're only able to access housekeeping for up to 2 years post-collision. Damage to clothing, glasses, hearing aids, etc. In past, for July 1st, if you are wearing clothing and they're damaged or destroyed due to collision, your prescription glasses are lost or damaged, hearing aids, prosthetics, they would be automatically considered for replacement if required. Going forward on July 1st, those types of expenses would only be covered if you have optional benefits purchased on your policy. And lastly, death benefits, funeral benefits. Previously, we've seen coverages $25,000 for a spouse, $10,000 for dependents, paid if an individual is killed as a result of an accident. Funeral benefits have paid up to $6,000 to reimburse funeral costs. Here now, we're only seeing those amounts made available if the optional benefit is purchased. Again, family circumstances. Some families in Ontario have excellent coverages already for life and disability and whatnot. Maybe people don't need the death benefit or the funeral benefit on the auto policy. Others have no such coverages. These are the types of questions that we have to ask ourselves, or that brokers or insurers have to be asking their customers at the point of purchase of policy. Dependent care benefit coverage limit is fixed by the optional benefit. To be honest, this is a benefit that I have very, very rarely seen accessed in an accident benefit claim. What it's for those who might not know, the dependent care benefit can pay if I am an injured worker and I decide to return to work and I put all of my resources into work And when I come home, I have dependents, be them my children or elderly parents that live with me. I've put so much of my resource into my work during the daytime that I need to hire help for my dependents at home in the evening. So it's not a caregiver benefit. It's a different purpose. It's I have no resources left. I'm completely tapped. I need to go home. I need to go to bed because I've spent my day working. Dependent care benefit can pay to provide services after the workday is complete in order to facilitate my return to work. In theory, an income replacement benefit and a dependent care benefit can be received at the same time in certain situations. And then indexation, no reform here. So this is the one that was, let's say, left alone. Indexation is an option. It's been an optional benefit for years. Optional benefit still. It is, if purchased, its purpose is to increase the weekly indemnity benefits that are being received for year-over-year inflation. So we talked about an income replacement benefit historically has been at $400 per week. If you have the indexation option purchased on your policy, that $400 per week would increase year over year if you were receiving that benefit on a long-term basis. So that's a benefit still available for purchase. Okay, so who is covered? Optional benefits. So we know now that the only mandatory benefits on policies will be medical rehab and attendant care. Everything else is optional. If I have purchased on my policy the optional income replacement benefits, maybe the optional supplementary medical rehabilitation, and I've purchased death and funeral benefits. If I get involved in an accident, I've got passengers in my car, the only people that can access the optional benefits on my policy are myself as the named insured, my spouse, if I have one, my dependents, if I have them, both my dependents and the dependents of my spouse, if we're a blended family, and any person specified in the policy as the driver of the insured automobile. So if we think of a scenario where I'm driving with a good friend of mine and we each have our kids, they're in the back seat, I get into the accident, it's my vehicle, and let's say that my good friend is not an insured individual, not married to anyone, so she is going to come to my auto policy to claim. Myself and my kiddos, for an accident that happens on or after July 1st, myself and my kiddos will be able to access the mandatory coverages and the optional coverages. My good friend and her child cannot. My good friend can only access the mandatory coverages for med rehab and attendant care because she is not a named insured, she is not my spouse, she is not my dependent, and she's not named on my auto policy. So it does really restrict coverages that would, coverages available for people that are otherwise uninsured. We'll talk a bit about transitions. So coming into July 1st, what can we expect? For existing policies, any policies written or renewed right up until June the 30th, the policies will retain all of their coverage limits beyond July 1st, 2026. So right now, my policy, exactly as it is written, will continue to have the exact same policies, or the exact same coverages beyond July 1st, 2026. Policies renewed on or after July 1st, 2026 will automatically renew with identical coverages and limits, which is good news for consumers. What this means is right now, my standard coverages with, let's say I have an optional increase in my medical rehab and I have an optional increase in my income replacement benefit up to $1,000. If my policy renews on July 2nd, I will keep those exact same coverage limits because the default is to opt in to optional benefit coverages. The coverage is only removed if an insured explicitly declines the optional coverage in writing. That's for renewals. However, just because my policy is not renewing on July 1st doesn't mean I can't make changes. So if I want to, on July 2nd, make a midterm change, I can call my insurance company and I can make reductions. If I've read in the news that mandatory coverages are reducing strictly to med rehab and attendant care, my finances are strained, I think it's a good idea. I can call my insurance company and say, please remove all other insurance coverages under the accident benefit portion of my policy, apart from med rehab and attendant care, and that can be done. New policies. New policies are going to be working different. So if come July 2nd, I decide that I no longer want to work with my insurance company and I call up a new insurer and I want to get a new policy, by default, that new policy will only include mandatory coverages. So the new policy will only have the med rehab and attendant care, and I have to actively ask for, actively purchase any optional benefits. So that's the massive change. Renewals, if I'm simply renewal, I'm staying with my same insurance company, I will have the exact same coverages for a renewal after July 1st as I had before. But if I'm purchasing a new policy, I have to expressly opt in and choose to purchase if I want optional benefits. There are a couple of immediate changes to take note of. So regardless of when the policy renews, for any and all accidents occurring on or after July the 1st, regardless of renewal date, it will become the fact that only the named insured, their spouse, dependents, and listed drivers will have access to benefit coverages beyond the med rehab and attendant care. So again, keep in mind, if I'm in a car, I've got my good friend and her child in the back seat. In past, she might have been able to access an income replacement benefit under my policy. If she was hurt, unable to work, she had no other policy to look to, she's claiming on my policy, she could access income replacement benefit if the accident happened on June 30th. If the accident happens on July 1st, July 2nd onward, as an uninsured passenger in my vehicle claiming on my policy, she will no longer be able to access an income replacement benefit or any of the other now declared optional benefits. The other change immediately taking effect as of July 1st, regardless of policy renewal date, is that change in who's primary for payment. So we talked earlier about the fact that in past extended healthcare coverages were primary for payment. I would first submit my healthcare expenses to my extended health plan. Auto insurance would pay the balance. As of July 1st, that immediately changes, again, except for prescriptions. Extended healthcare coverages will be primary payment for those. All right, we're going to shift gears just a little bit to talk about optional benefits and priorities of payment. So here in Ontario, we have a hierarchy. We often talk about priority of payment for accident benefits claims. So how do I know if I'm involved in an accident? How do I know which insurance company is going to handle and pay my claim? Well, this comes out of the Insurance Act, and you'll see the 4 bullet points here on the screen. So a claimant has first recourse against their own auto insurance policy. That's simple. It makes sense. I pay my premiums to my insurance company. If I'm hurt in a car accident, I call up my insurance company and they pay my accident benefit claim. And the same goes for my spouse or my dependents, or listed drivers for that matter. If I have more than one policy, let's say I've got a regular everyday car, I've got a summer car that's fun, and I've got my motorcycle. I have to, in most cases, apply to the policy of the vehicle that I was occupying, unless I had optional benefits on one of the policies, but we'll get into talking about that a bit further. If I wasn't an occupant of my own vehicle, then I would have absolute discretion. I could apply to any of my own insurance companies. But let's say that I'm not a named insured. I'm not a spouse of a named insured. I'm not dependent upon a named insured. I'm not a listed driver on any insurance policy. Well, what happens then? So this is where the hierarchy comes into play. The next recourse would be that I would apply to the insurance company of the vehicle that I occupied. So this is my girlfriend who's a passenger in my car. She's not insured. She's not a spouse. She's not a dependent. She was an occupant of my car. So she would receive her accident benefits from my insurer because she occupied my car at the time of the collision. But let's say that my insurance had lapsed or I never had insurance. She's an occupant of my car is not insured. Then it goes to the next level down, which is that she can submit her accident benefit claim to any policy of any other vehicle involved in the collision. So it's a T-bone collision at an intersection. She's an occupant of a car that's not insured. She would go to the policy of the other vehicle as next level. Worst case scenario, none of the cars involved in this collision had insurance active. Then we go to the Motor Vehicle Accident Claims Fund, which is the safety net, the catch-all, so to speak, to ensure that anyone involved in an accident here in Ontario eventually will have benefits available to them. Why does this matter? Well, it matters because of these reform changes. So in past, as I talked about, if I have more than one policy and I have optional benefits on one of them, it makes sense that I would go to the policy with optional benefits. So back to this example, if I have a winter car, a fun little summer car, and a motorcycle, I don't need to purchase optional benefits on all three of those policies because there's an endorsement, the OPCF 47, which says that I can apply for my accident benefits to the policy that has optional benefits. And that protects me, right? Because if I have $1,000 of income replacement benefit available on my vehicle policy, but I'm hurt while riding on my motorcycle, I want to be able to access that $1,000 of optional coverage on the vehicle claim or on the vehicle policy. With the July 1st changes, we're seeing a nice change come into effect with this endorsement. So we've had problems historically in that the OPCF 47 is available to people, but sometimes inadvertently folks would apply to the wrong insurance company for their accident benefit claim. Think for a moment of a trauma. A motorcyclist is involved in a terrible accident. They're in ICU at Sunnybrook, and their well-intending mother calls the insurance company for the motorcycle, says, my son's been very badly injured. I need to open a claim. The claim gets submitted and off they go. And weeks or months down the road, this motorcyclist realizes that the claim should have been submitted to his vehicle because the motorcycle policy had standard coverages, the vehicle policy had optional coverages. This is a big problem because numerous arbitration decisions have found in that circumstance that the injured claimant cannot shift his claim from the motorcycle policy with standard coverage to the auto policy with optional coverage. The OPCF 47 allows us to choose where to submit our accident benefit application, but once that choice has been made, we can't change it. And there's been many situations, many claims in past where this has happened and individuals have lost the access to optional benefits because of a mistake at the outside of a claim. This has been corrected. So as of July 1st, 2026, a claimant who inadvertently applied to the wrong policy that didn't have optional benefits will be able to make a change. And that's because the OPCF 47 is being replaced by the OPCF 47R. And this OPCF 47R will allow for the claimant weeks or months post-collision to make a written election to execute and move the claim to the correct policy so that they can access their optional benefits. So again, just to reiterate, we don't need to buy optional benefits on each and every one of our policies. We just have to work to get our claim to the correct policy if we're in the unfortunate situation of suffering injury due to collision. Now, one little issue with this OPCF 47 and OPCF 47R is that the transition of that endorsement will only come into effect at renewal or if there's a midterm policy change. So if my policy doesn't renew until September, between July 1st and September, I still have the old style OPCF 47 on my policy, which means I still have to be really cautious if I'm involved in an accident to be sure that I submit my claim to the policy that has optional benefits to ensure that I have increased coverages. Okay, anticipated impacts. So these are some pretty big changes. First and foremost, it really comes down to money. That's why we've seen these changes being brought out. The government and FSRA in collaboration, they're looking to reduce premiums. Finances are strained across the province, across the country, and we are so very often hearing of challenges and consumer complaint around rising insurance premiums. So FSRA's estimate is that the shift to a la carte benefits will cut average mandatory premiums by about 5%. on the whole, on the entire policy package. I've read that the hypothesis is that it will cut accident benefits, the portion of policy related to accident benefits, by perhaps about 19% on average. Of course, this is going to depend on what consumers decide to purchase. Every policy is going to be very different, of course, but some policies will stay the same, some policies will reduce, some might increase depending on what optional benefits are purchased. But overall, FSRA is hopeful that we'll see a reduction of premiums of about 5%. I think it's fair to anticipate that the changes coming July 1st will result in pretty gradual changes for coverages. And that's because of the default set that coverages will continue on renewals, right? So we had talked about the fact that a policy, if you stay with your same insurer and your policy renews anytime after July 1st, you're not reducing straight down to those mandatory coverages. You're keeping the exact same coverages unless you voluntarily opt out of them. So it's very probable that most renewing policies will renew with the exact same coverages, perhaps because insureds aren't aware that they have the option to reduce, or they just naturally stick with what they've already got. Maybe they didn't get a phone call, they just got a renewal package in the mail, they didn't read it. But gradually, we're going to see changes in coverages as people become more aware, and also as people change insurance providers and are actually given the choice to opt in versus to decline coverages. Another anticipated impact. We have a lot more pressure, of course, on insurers and on brokers to explain how the coverages work, what's available, why it's important, and how the coverages can work. We can imagine that there will probably be an increased risk of lawsuits against insurance companies and against brokers where insureds get into catastrophic collisions. They don't have an income replacement benefit, for example, or there's no death or funeral benefit and a spouse has lost their partner. And you can imagine that insureds are going to say, yeah, but I didn't know, nobody told me. And this is a risk that we see, of course, with every legislation change, but this particular change is significant and perhaps more severe. So we can imagine that there's a chance of increased risks against brokers and insurers that yeah, but I didn't know that coverages will be brought into question. And with that, brokers and insurers really must understand the changes and do their utmost to explain the changes to their customers, but also to document what was communicated and what was purchased. There's, of course, also an onus on the consumer in making these decisions and asking questions. When we were talking about income replacement benefit, I talked about the fact that the coverage is $400 per week, or it has been historically as a standard coverage, but I don't automatically get that $400 per week. As a consumer, when I'm talking to my insurer or my broker and I'm trying to decide, do I need the optional income replacement benefit? Am I aware that I have disability coverage? What percentage would be paid for short-term disability? Do I have sick leave? Do I have long-term disability benefits? Does my spouse have coverages? Consumers really need to be thoughtful when they're making the decisions around what coverages to purchase. And I think it'll be an interesting atmosphere to see how involved policyholders will become when they're facing the renewals and facing new purchases. Adjusters have always had a massive onus upon them, the burden to understand coverage and to make sure that they're effectively communicating with their claimants where there is a claim that's been brought forward. We've seen in past that adjusters have not always been perfect, I'll say, in communicating coverages, coverage decisions, and rationale around reductions or denials of benefits. Now more than ever, with all of these changes, adjusters are going to have to become a lot more efficient and sophisticated in understanding what coverages are available on policies. They can't assume that a claim has particular coverages. They really have to get in depth in reading and understanding the coverage available even before that very first phone call. With their claims notices, they have to be sure that they're effectively communicating, that they're correct in their interpretations, and failures in communication or determinations of coverages, as always, can result in cost consequences for the insurance company. Sometimes we can see requirement to pay consequences where, at the LAT, for example, a determination or a coverage determination could be overturned. And there could also be cost consequences to the insurance company in terms of compliance audits or in terms of special awards in certain situations. Positive changes for insurance companies. We can definitely expect that administrative costs will reduce over time on the more basic policies. There's going to be a less need for insurer examinations, accounting services, legal services, etc. And the reason you can see this as a, I think, definite outcome is that if we're talking about a policy that simply has medical rehab and attendant care coverage, there is no income replacement benefit. We're not going to have insurer examinations to address whether a person has continued ongoing entitlement to income replacement. In past, an insurance company might set up an insurer examination with medical assessors of their choosing at a year post-accident on a significant injury to check and see if a person continues to have entitlement to income replacement benefit. And that insurer examination might cost $10,000 or $12,000. And at the 2-year mark, they might do it again to determine whether the person has a complete inability to engage in employment. And that might cost $16,000 or $20,000. And so when we're talking about these policies that no longer have income replacement benefit coverages, those are eliminated. And with that, the disputes are eliminated. With no dispute of income replacement benefit, we're not going to the LAT. We're not seeing the forensic accounting reviews, and we're not having to engage defense counsel. So just a much simplified claims process and reduced costs overall. And there too, shelf life. I think it's probably reasonable to suspect that shelf life will reduce on these more basic policies because we won't see the long tail claims where income replacement benefits continue to be paid or where there's disputes before the LAT. If we have a situation where at a year we're able to be talking about settlement because we've only got medical rehab coverages for up to 5 years, it's a much easier claim to quantify and to fairly resolve on a full and final settlement basis than if we're still thinking about, is this person going to have an income replacement benefit beyond 2 years or to lifetime for that matter? So we should probably see quicker and more efficient settlement discussions and shortened shelf lives. So we already covered this point, but with the absence of optional coverages, we'll likely see a reduction in LAT applications because there's going to be fewer disputes. And this one's the most painful one. So claimants who do not qualify for optional coverages will only have access to standard med rehab and attendant care coverage limits. This burden on uninsured individuals in Ontario is going to be severe. You think about that same scenario, my best friend in my passenger seat, and she's not insured, she's not married to an insured, she's not dependent upon anyone, and we get into an accident together, she has no access to an income replacement benefit, period. Worst case scenarios, she's killed in the accident, there is no death benefit available, no funeral benefit available. These are the changes that we're going to see, particularly I think with people who, they don't have driver's licenses, they don't have insurance, the cyclists, the pedestrians, maybe the, students that are here in Ontario on a student visa. These are the folks that are really going to be affected by these changes because they'll be so limited just to med rehab and attendant care. And then here too, policyholders. Policyholders are going to have a really large burden upon them to be sure that they're purchasing coverages that make sense to their family situation. So if I'm the insurance decision person in my household, I have to remember that whatever coverages I purchase on my policy will also impact my spouse, my dependents, and any listed drivers that might be on my policy. So let's say that I have an 18-year-old son who's still dependent upon me. He's living at home. He's listed as a driver on my policy. He's working full-time through the summer and, heaven forbid, gets into a horrifying accident, catastrophically impaired, and never works again. But I had decided at the point of purchasing my policy that I didn't need an income replacement benefit. My son won't have an income replacement benefit because of that decision that I made in purchasing my policy. So again, it's just sort of some of the things that we have to think about, both for our own well-beings as consumers, but also if we're in the business of selling or explaining insurance products to customers. Priority disputes. So we talked about the hierarchy of priority here in Ontario. If I'm injured in a car accident, I first go to my own policy or the policy of my spouse, or if I'm dependent upon someone, then I sort of run down that ranking. In past, we've seen all sorts of priority disputes. I think we're probably going to see more. And the reason for that is, let's say my son is now 21 years old and he's away at university. He gets involved in an accident and he comes to my policy for a claim, and I have optional benefits. There is an increased interest or an increased focus perhaps in considering whether or not he is dependent upon me and whether or not my policy should be the policy to respond to his claim. In theory, that focus has always been there, but I think that we might see that increase even further, because if he's not dependent on me, then his claim needs to go elsewhere, and maybe he won't have optional benefits available on whatever other policy he falls to. I think that this is probably something that will become a little more litigious than it's been in past. Business and fleet policies. I personally do a fair amount of work in trucking claims. I do a lot of commercial fleet policy work. In past, if a driver has been someone who has regular use and access of an employer vehicle, they're considered a deemed named insured on the employment vehicle, and in past, they've been able to claim against the fleet policy. I don't know that we're going to see that happen so much going forward, because we can imagine that a lot of these commercial businesses probably aren't going to purchase optional benefits. So if an employee driver is involved in an accident while operating a work vehicle, they're going to want to consider, do I go to my employer's vehicle that has only standard coverages, or do I go to my own policy where maybe I've purchased optional benefit coverages? And I think probably we're going to see a shifting where more and more people are going to their own policy if they have those optional benefits available. And then lastly here, with more people underinsured, so if I haven't purchased income replacement benefit, or if I'm not cyclist or pedestrian, we're surely going to see increased pressures on public services and systems. So employment insurance, Ontario Works, ODSP, OHIP, etc. And I think that's probably going to be compounded by the fact that if I'm injured in an accident and I don't have an income replacement benefit immediately available to me, maybe I'm returning to work sooner than I otherwise might have. We kind of have to wonder if there might be an increase in chronic pain type of syndromes, or where people aren't fully accessing the rehab and care that they require because of financial strain. If your basic needs aren't being met, let's face it, you might be skipping out on the physiotherapy because you're instead investing yourself back into return to work as quickly as possible, even though maybe you're not recovered. And then tort impacts. We haven't really talked about this because it hasn't been our main focus here today, but it's a reality, I think, that we're going to see more lawsuits. So we started this presentation by talking about pre-1990, where we were a purely fault-based system, and we almost always saw individuals suing where they're not at fault. They're suing the at-fault party for their economic damages, their pain and suffering and whatnot. I think we're probably going to we can safely assume that we're going to see an increase in the reliance upon the tort system for economic damages. So where individuals don't have an income replacement benefit, or they're that cyclist or that pedestrian who doesn't have access to optional income replacement benefits, I think we're going to see more and more lawsuits being brought forward into that fault-based model of claims, where there is another party at fault for the collision. And I also suspect if there is an absence of a viable tort opportunity, so let's say that it's a single vehicle accident and I have no one that I can sue, I don't have an income replacement benefit, I only have the standard, the mandatory med rehab attendant care, I suspect it's likely that personal injury law firms may have less of an appetite to represent individuals that only have mandatory accident benefit coverage is available and no tort opportunity, which may mean that such claimants will have reduced access to legal representation and support in relation to their claims. And that brings us to our close. I see we're at 12:55, so we will have a little bit of time for some questions, if there are any questions. Just to regroup, again, we're shifting from the no-fault heavy SABs regime to a leaner mandatory model, this a la carte, as it's being called. Medical rehab, attendant care coverages will remain mandatory. Everything else is optional, but again, keep in mind that renewing policies will renew with same coverages. Existing policies retain the same. New policies will have to have add-on coverages actively purchased. So with that, I thank you all for your time and attention. I hope that this has been informative and helpful to you. As you can see here on our question tab, again, Michael McNeil regrets that he wasn't able to join us, but by all means, please reach out to Mike if you have anything after today that comes to your mind, or you'd just like to run through anything. And of course, we'd be happy to take any questions here and now.
We do have some questions. So let's see, our first one is, can we discuss who's covered when the named insured is a corporation?
Yeah, so that sort of comes back to that really brief mention that I made there about employer policies. If I'm a trucking company, oftentimes my policy, I'll have a fleet list where I'll have scheduled vehicles. Oftentimes I also have scheduled drivers, although not always. Under the accident benefit regime, an employee who has regular use and access of an employer vehicle at the time of an accident, if they're occupying that vehicle at the point of collision, they're typically considered a deemed named insured. Not always, it can get litigious and there can certainly be fighting around that, but for the most part, an employee in an employer vehicle will be considered a deemed named insured. So for the priority rankings and also for optional benefit coverages, they would have access to optional benefits if there's optional benefits on that corporate policy. We would expect.
Okay. And how is it determined that someone is a dependent?
That's a big one. Lots of times at the LAT, someone is dependent if someone is independent if they are able to meet at least 51% of their financial needs. So when we talk about dependency, we have financial dependency and then also the physical dependency. So, younger children that rely on parents for their everyday needs. But where it gets complicated is that sort of gray area between, let's say, age 17 and 25, where our young adults are transitioning from being fully dependent to being fully independent adults. And oftentimes that comes down to an accounting review and a whole lot of analysis in terms of understanding the individual's circumstances prior to the collision. And that 51% measure is what we're looking at. So basically you're talking about poverty. If you can only meet 51% of your needs, if a 18-year-old has a part-time job making $25 an hour, 20 hours a week, and they're saving all of their money for tuition, and their parents pay for everything, their car, their insurance, their groceries, the kiddo doesn't pay rent, that doesn't mean that they're dependent on their parents, because that can be a choice. It comes down to the economics. It's that they're making $25 an hour, working 20 hours a week. And if you look at what their financial obligations are if they were to live independent, that's kind of the measure. It does take a lot of effort to work through those intricacies, and a lot of times they can go either way, and a lot of times they do go to the license appeal tribunal, or if it's a priority dispute, they'll go to private arbitration.
Okay. We would like to revisit eligibility for non-earner for a minute.
Sure.
Just in terms of, the question is, I believe you said up to age 18, I thought it was applied to anyone not eligible for an income replacement benefit and not receiving caregiver benefit. Can we just go over the criteria for that one?
Yeah, for sure. So a non-earner benefit, it's a really strict test of disability. So to be able to receive a non-earner benefit, you have to suffer a complete inability to carry on a normal life. Case law tells us that that doesn't mean that you're bedbound. It looks at what was your normal life like before. So if your normal life was that, you would wake up in the morning and you would walk the dogs and you were really involved in a certain set of hobbies and you love to read, and it considers who you were before and whether you are unable to carry on with that normal life post-collision. And it's payable to individuals who are at least 18 years old. Before 18, it's simply not available. It's payable at $185 per week for up to 2 years, but not for the first 4 weeks. And in order to qualify for the benefit, you have to meet that disability test, so a complete inability to engage in a normal life, and you have to either have not qualified for an income replacement benefit, or you have to have been either a full-time student at the time of the accident or someone who has graduated from full-time studies in the year prior to the accident, but you're not yet involved in an occupation that fits your education level. So sort of a few different factors there, but that's sort of the standard of determination. I hope that helps.
Perfect. How do you see these changes impacting commercial transportation fleets or captives?
Yeah, I do a lot of work in that realm. I wish we had crystal balls, in all things in life. To be honest, I think we're going to see a lot fewer accident benefit claims coming into the fleet policies. My instinct tells me that more and more people are probably going to go to the personal policies because they will still have optional benefits on their personal policies, at least for the first while, right? So if you consider that the personal policies at renewal are going to maintain the exact same level of coverage, the average everyday Ontarioan are still going to have an income replacement benefit at renewal, whereas those fleet policies, I think, probably are going to reduce down to only mandatory coverages. So when that employee driver is faced with the decision of, do I go to my employer's policy where I can't have an income replacement benefit, or do I go to my own policy where I can? I think they're going to bring their claims to their own policies. Sometimes people are averse to bringing their claim to their own policy for fear that their premiums will go up. We get that question all the time. My answer always is that in theory, it's a no-fault accident benefit. It shouldn't affect your policy premiums, but to call your insurer if you have questions, to call your broker, or to call your customer service department. But I think when faced with the decision of no income replacement benefit versus income replacement benefit on my personal policy, I think most people are going to be willing to take the risk or face that fear that their policy premium might go up because the income replacement benefit is so attractive. Assuming that that's how significant their injury is. If it's a more minor injury and they don't have an income replacement, it'll probably still go to the fleet policy. But in the more significant claims, I think it'll be a shifting.
Yeah. I think we just have 2 more, so we should just be a few more minutes. And I guess sort of in the same vein, how do you see the rideshare industry being affected by this?
Yeah, that's interesting. And I wish I was a little more in tune with this than I am. It's funny, Mike McNeil and I had a conversation about this just a few days ago. My understanding of Uber, as an example, is that if you're injured in an accident while your Uber app is active, I believe you have to go to the insurer of the Uber app. I don't know if you have a right around that. And to be honest, I don't know how that OPCF 47R is going to affect that. So that's going to be a takeaway for me for sure, and maybe for Mike McNeil as well. But I think that's a really great question, and I think it needs a little more analysis.
Okay, that's fair. And the last one, hold on. So it's a bit of a longer one, but how do you see the impact of the definition of insured impacting people who rely on public transit, riding in taxis, school buses, who don't have a license, who aren't dependent, outside of like what the legislation states, the like industry impact, social impact of this reform?
Yeah, sorry, can you say the very start of that question again? You blurred out for a second.
Sorry, how do you see the impact of the definition of of an insured impacting people who rely on public transit or taxis who aren't named insureds on any policy?
Yeah. I mean, the good news is that any Ontario resident involved in an accident is protected by the standard accident benefit regime, regardless of fault. So, to be considered an insured under a policy, you need to be that named insured spouse, dependent of, or listed driver. But for the purpose of accident benefits, anyone, any Ontario resident injured in an accident in North America, really, in Canada or the US or any port between, traveling on a vessel in between, is considered an insured person for the sake of being able to make a claim for accident benefits. So, we're going to see these individuals without access to any of the optional benefits. It's going to be that $3,500 strict for minor injury, or $65,000 combined for med rehab attendant care for non-catastrophic, or $1 million for medical rehab attendant care for catastrophic. And that's simply the maximum amount that someone who's not on a policy, not that named insured spouse, dependent, or listed driver, is going to be able to access. So, I mean, as far as impacts go, I think it's going to be devastating for some people. You're in your 20s, you live downtown Toronto, you've got a condo, you walk to work, you take the bus, you ride your bike. You don't yet have a job that offers particularly generous disability benefits. You don't yet have savings or, a real safeguard there. And then you're injured in an accident. And suddenly you find yourself with just, let's say $65,000 of coverage for medical rehab attendant care, and you have no money. You hope that you're not at fault, because then you can sue the at-fault party. And let's face it, that's a viable opportunity in lots of these cyclist pedestrian accidents. We almost always see lawsuits. Even if there's a partial fault, it's still an outcome that typically we see compensation flow from. So the problem, though, with tort is that it takes a long time. You can start a lawsuit anytime within 2 years, typically from the date of an accident, but more often than not, they take 3 to 4 to 5 years to resolve. So, what do you do in the meantime if you've suffered a moderate brain injury and significant physical injuries? Apart from move back in with mom and dad, or hopefully you've got some support network that can catch you. But yeah, the short, easy answer, if I can call it that, is that I think it'll be pretty devastating to some of these folks that are not considered insureds on policies, and to the public system, for that matter.
For sure.
On that cheery note.
Well, since I've run a bit, thank you to those of us who have stuck with us until now. We're going to wrap things up here. I know there's a few more questions. We'll get back to you offline with answers and resources for the questions that we didn't get to in the chat. We'll just remind you that the session was recorded, so we will be sending that out afterwards, and it will also be up on our Crawford YouTube channel for you to watch or share with your team. Thanks again for everyone for coming and for engaging us in this discussion. We hope you found it informative, and we will see you next time.
Thanks, everyone.